Hello everyone. This is a group presentation of class 13G Administrative Law. Our group members are Arshdeep Singh, Dilshad Khan, Manveer Singh, Navjot Kaur, Kamalpreet Singh and Saharish Harishbhai Pasana. The case we are talking about is Khanij v. Roger Cable Inc. 2002. We will talk about facts, issue, holding, rationale, question answer about the case. Starting with the facts, this case decided in 2002 by Ontario Supervisor Court of Justice dealt with whether a company could change its contract terms without directly telling its customer. Let's start with the people involved. The case was brought by Mr. Khanij and a group of Roger Cable Internet customers. They were unhappy with the change Roger made to its service agreement. Roger Cable Inc. is one of the Canada's biggest telecommunication company. Here is what happened. Roger updated its term of service to include a rule saying that the customer had to settle their dispute through arbitrations instead of filing a case action lawsuit. But instead of notifying customer directly, Roger only posted this on its website. The customer argued that it wasn't fair way to inform them and the arbitration rule was unfair. When the case went to court, the judge ruled that in favor of the Rogers. The court said that because the service agreement allowed Rogers to change its term, customer had to accept the new rules. The judge also decided that posting update on the website was enough to count as proper notice. The decision was important because it showed that the company could legally change their contract as long as they followed their original terms. It also reminded the customer to pay attention to the service agreements, especially when in digital age, where update might not be directly sent to them. In the end, the case teaches us always to read and understand the terms of service for the product or service we use.
Well, there are four types of legal issues. Firstly, extension of agreements. Second, arbitration causes. Third, burn of proofs. And second, arbitration causes. Firstly, we can talk about extension of arbitration agreements. This means the agreements to by the government dispute from arising for the using service. In this user agreements, the plan left dispute extension order aborted. Government extension, they were not properly notified about the change to agreements, including this additional Arabic agreements. Secondly, we can talk about Arabic causes. The painful claim will provide the notice to Arabic causes. There are there are no there are no proof, no provide any information to Arabic agreements, and it did not notify to the subscribers to clean the way agreement has been adamated, and particularly including the causes. On the other hand, agreements is given multiple channels, including emails, websites, posting, and newsletters. Third, we can talk about burden of proofs. The court of the court defines as burden of proof arbitrations agreements and the traders that stay under the this act. The pain life has been burned of the proving among the expectation of the such as agreements of government, unconditional and reasonables. Last but not least, Arabic causes. The painful also arise of the issue of the whether to causes unconditional evils due to lack of proper notice as well as due to lack of proper knowledge. This involves conditions whether the agreements to the user enable and whether the painful has the gene's opportunity to revive a chance of the choosers. Last but not least, amendments to the user agreements. The central issue whether it defines the give the notice to the customer to user regarding includes Arabic causes. The weather we can talk about in this agreements there are lots of problem to the peoples. As well as there are lots of give a chance to the governments. And uh, in previous we can talk about burn of foods, which proved that the causes as painful as burn of providing carbon extraction to such agreements to the increase and costable and the reasonable provides.
Hello, this is Manveer Singh. Now I would like to talk about the holding of this case. The Ontario court ruled in the favor of Rogers Cable, upheld the enforceability of the arbitration clause added the service agreement. The original agreement includes modification clause that allows Rogers to change the terms unilaterally. Customer had already agreed this condition when they signed up the service. The Roger had the legal right to amend the contract. Notice of changes. Posting the update terms online was sufficient notice. The court held that customer had a duty to check the update, no direction notification. Acceptance by conduct. By continuing the use the service after the update terms were posted, customers were deemed to have accepted the modified term. This follows the principle of acceptance by conduct. Enforceability arbitration causes. The court reinforced the validity of arbitration causes in consumers agreement, prevented customers from pursuing class action lawsuits, required dispute to be resolved through arbitration. Key legal principle applied. Contractually, freedom and modification causes. Sufficiency of notice through online posting. Acceptance by conduct. Enforceability of arbitration causes which are generally upheld unless found to be unconscionable or improperly communicated.
Hi, my name is Kamalpreet Singh. Today I will talk about the case Kenneth and Rogers Cable Incorporate Limited. Basically, this case means that is a decision by the Ontario Superior Court Justice dealing with the contract law and arbitration clauses. So now I will discuss some key rational points on the behalf of this case. The first one is legal basis for the decision. In this case, the court's choice was based on built-up standards of contract law, especially with respect to the enforceability of intervention clauses in standard shape assumptions. Intervention clauses are and by large maintained unless they are found to be inconscientiable or against open approach. Equity depended on point of reference cases that affirmed intervention clauses are substantial on off chance that the customer has concurred to them. Indeed, in contracts where terms are independently arranged, the administering strengthens the guideline of chance that a shopper acknowledges a contract, whether effectively or by proceeding to utilize the service. They are lawfully bound by its terms, counting the assertion clause. The second point of this case is the role of notice and amendment clauses. A key issue in this case was whether Kenneth was appropriately educated around the assertion clause. Rogers had a revision clause in its contract permitting the company to alter terms singularly. The overhauls posted on its site, Kenneth contended that he was not given satisfactory take note, but the court found that posting the changes online satisfied the legally binding notice prerequisite. So furthermore, since Kenneth had a concurred to the benefit ascension, counting its alteration arrangements. He was considered bound by these changes. The choice reflects that court approach of maintaining legally binding ascensions as composed, instead of evaluating whether a clause is essentially reasonable or helpful for customers. Apart from this, the third point of this rational points behind this case is the broader legal implications. So further, this judgment focuses to more extensive concerns with respect to the complicated adjust of powers pertinent in buyer contracts. There are numerous standard assumptions, as in this case, give firms with the significant scope to force terms upon shoppers with the small or no room for arrangement. This may allow rise to questions or procedural decency, particularly in circumstances where companies basically alter contracts on their claim agreement without advising customer. What this administering can be seen to cruel is that courts are fundamentally willing to implement intervention clauses, which look for confine the consumer's capacity to prosecute. Adding more in this case, this takes after an rising slant whereby the courts are underwriting arbitration like forms for settlement or debate, subsequently assisting and motivation for the companies, making conceivable confinements on the consumer get to conventional courts. So that's all about this case and the rational points. Have a great day. Thank you.
Hello, my name is Navjot and now I would like to speak about some questions which I find from these whole factors. The first of the question is, why did the plaintiff, Mr. Canties, and other subscriber contended that arbitration clause was invalid? According to my research, the plaintiff contended that the arbitration clause was invalid because they were not sufficiently notified of the amendment of service agreement. They claimed that merely posting the amendment on the website without consideration notice was not enough, was defeating. Next question is, what was the argument of Rogers on notice of the arbitration clause? The argument of Rogers was that they provided proper notice of the arbitration clause in a several ways, including web posting, mailing, newsletters. They argued posting on their website of a new terms was sufficient and satisfied notice in contract. And the third question is, what did the Ontario Superior Court of Justice hold regarding the enforceability of the arbitration clause? The court ruled that notice to be reasonable as it was placed on the site for anybody ready to register his or her preference to have in mind. The court ruled customers already to be under contract in the first contract, including the province of a unilateral modifications and giving a notice on the website to be sufficient. The fourth question is, what did the court rule regarding the notice feature of the arbitration provision? The answer is that the court ruled that putting the new terms on the site was a sufficient notice and customer have to go seek out changes. The court ruled that notice by direct communication like a letter, email was not required because customer were held to have argued to the new terms by continuing to use the service.
Hi, my name is Sir Sarish Bhai Parsana. Today I am going to say the conclusion of our case. First, case overview. The dispute revolved around Rogers Cable unilateral amendments to its user agreement, particularly the introduction of an arbitration clause that was challenged by the plaintiff. Second, valid notification. The court ruled that Rogers' method of notifying user about the changes via posting on its website was a valid form of communication. Third, original agreement provisions. The court determined that the original contract allowed for amendments, including the addition of an arbitration clause without further active consent from users. Fourth, enforceability of arbitration clause. The court upheld the enforceability of the arbitration clause, which require disputes to be resolved through arbitration rather through court action. Fifth, binding nature. By continuing to use the service after the changes were posted, customers were considered to have accepted the revised terms, including the arbitration clause. Sixth, unconscionability of clause. The court rejected claim that the arbitration clause was unconsiderable despite the imbalance in bargaining power between the service provider and individual customers. 7. Arbitration versus class actions. The court ruled that the arbitration clause, which prohibited class actions, did not conflict with the Class Proceedings Act, as both could exist. 8th, arbitration cost. The court noted that concern about the cost of arbitration was speculative and insufficient to invalidate the arbitration clause, referencing prior case law. 9th, punitive damages. The plaintiff argued that the claim of punitive damage made the case unstable for arbitration. The court disagreed, explaining that punitive damages are a form of relief, not a separate cause of action. 10th, summary judgment consideration. The court determined that it was too early in the proceedings to assess whether a summary judgment motion was appropriate. 11th, stay of proceedings. The court issued a stay of the lawsuit, enforcing the arbitration clause, as no expectation in the Arbitration Act applied to invalidate it. 12th, consumer responsibility. The ruling emphasized that consumers are bound by the terms of service even if they do not actively renew or understand the updates. 13. Service providers' power to amend terms. The case reinforced that companies could amend their user agreement unilaterally as long as they had a provision in the original agreement allowing such amendments. 14th, impact on consumer rights. While this decision upholds the enforceability of arbitration clause, it highlights the need for consumers to remain diligent about reviewing updated terms of service. 15th, legal precedent. The decision set a significant predict in Canadian law, affirming the enforceability of arbitration clause in online agreements and supporting the use of electronic method of communication for legal notifications. Thank you.